Good morning. I'd first like to place my appreciation to the MBA Academy for this novel initiative of web lectures, particularly in this period of isolation when all of us are sort of stuck at our respective places. These lectures from various well versed and eminent persons would not only keep us usefully occupied and connected with our profession, but these materials, which I am informed are being uploaded in the social media, would also become a part of our libraries for future references. I am referring to the earlier lectures in this series. Simultaneously, as many of us in the legal profession are aware, cases are now being conducted through video conferencing. This undesirable lockdown period could be utilized as a testing ground or a gestation period for the ultimate establishment of virtual courts for the future. Today, I intend to share with you the object of, or rather, the object for enactment of the Commercial Courts Act. The Act is actually called as the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015. For convenience, we shall refer it to as the Commercial Courts Act. Before I embark on the objects of this legislation, let's have a quick glance on its purpose. The purpose of the legislation is to provide for the constitution of commercial courts, commercial division and commercial appellate division in the high courts for adjudicating commercial disputes of specified value and for incidental matters thereto. The purposes are very clear and unpretentious. One, it seeks to define what a commercial dispute is. And two, it seeks to bring in a new hierarchy of law courts to deal exclusively with commercial disputes. And for achieving these two purposes, it amends certain procedures provided under the Code of Civil Procedure, which is the third and most important aspect. We shall now briefly see these three aspects. The first purpose of the legislation is that it seeks to define as to what could be a commercial dispute. Section 2 of the Commercial Courts Act gives 22 examples of disputes which would be deemed to be a commercial dispute. Whether these 22 examples are comprehensive by themselves or is indistinct is a matter for adjudication, and hence I do not intend to go into the exhaustive nature of the definition for obvious reasons. It's a matter of time for the constitutional courts to hold as to whether any other dispute would either be or not be within the purview of the 22 instances referred to in the definition of a commercial dispute. But by and large, if I may say so, the instances referred to in the definition seem to be self-explanatory and self-conclusive. Now that these suits of commercial nature are identified, all pending suits would get transferred to the commercial courts, and cases which are filed after establishment of the commercial courts would go before the concerned commercial courts. Insofar as transfer of pending suits involving commercial disputes are concerned, such an exercise may have already been done by this time, since the Act came into force by the beginning of the year 2016, and the commercial courts and divisions would have been established by now throughout the country. The second purpose of the Act is that it provides for hierarchy of commercial courts. First is the establishment of a commercial court at the district level. Second is the establishment of a commercial division in the High Court having original civil jurisdiction, like the Madras High Court. This will be presided over by a single judge of the High Court. Incidentally, these courts are required to handle only such commercial disputes whose specified value of the subject matter of the suit is over and above rupees 1 crore. The third is the establishment of a commercial appellate division in the High Court, which shall be presided over by a division bench. All appeals, either from the decree of a commercial court at the district level or from the decree of a commercial division of the High Court, shall lie to the commercial appellate division, and such appeals would be disposed of within a period of 6 months. Thus, the highlight in establishing these commercial courts is that the hitherto provision of 3 or 4 appeals commencing from the trial court up to the Supreme Court has now been reduced to just 1 appeal. The reason for the reduction is obvious. It intends to considerably bring down the overall duration of the entire litigation. The incidental question you may ask is as to how the legislation ventures to curtail or restrict or reduce the duration of the original suit proceeding. That is the third and most important purpose of the legislation. It amends 3 sections and 10 orders in the Code of Civil Procedure. We shall have a quick glance on these changes made to the code, which will indicate that the purpose of these amendments is to abbreviate the then existing complex procedures in a civil suit. One would find that these amendments are deterrent and stringent in nature. For instance, Section 35 of the Civil Procedure Code grants complete discretion to the court to award costs in a suit which is in the nature of a non-commercial dispute. Whereas the amendment to Section 35 in a commercial suit deters a party to the suit from making any frivolous claim or indulge in any other conduct that would amount to wasting the time of the court. Subsection 2 of Section 35 capital A, which limits the cost to rupees 3,000, is omitted. And therefore, if the commercial court or the commercial division finds that the party to the suit has indulged in wasting the time of the court in any manner, the costs could be exemplary by looking into various factors provided therein. Imposition of costs would also be attracted for non-cooperation of the advocate during the case management hearing or for non-compliance of the orders passed in the case management hearing. I shall deal with the case management hearing in a few moments. Likewise, the time for filing of the written statement under Order 8 Rule 1 or under Order 5 Rule 1 was made rigorous, and while prescribing 30 days time limit for filing the written statement, the amendment gave discretion to the court to permit filing the written statement even thereafter, but within 120 days from the date of service of summons on the defendant. But such permission shall only be by imposing costs on the defendant. The catch here is, the moment this 120 days time expires, the defendant would forfeit his rights to file the written statement thereafter. In other words, the effect of this amendment is that as soon as the defendant receives the summons, he has to file the written statement within 30 days. But if he chooses to file it after 30 days, but before 120 days, he must be prepared to pay exemplary costs, and the defendant cannot circumvent the 120 days period since he will forfeit his right to file the return statement. Thus, the effect of these amendments enabling the court to impose costs would discourage a litigant who intends to come with a vexatious commercial suit or attempt to protract the proceedings and may make him to have a second thought to initiate such litigations. There are a few other amendments touching upon the mode in which the pleadings and affidavit are to be drafted, including the affidavit of evidence. Importantly, the manner in which the pleadings are to be verified and supported by statement of truth, and in case the pleadings are not properly verified in the manner in which it is provided for, the court may strike out such pleadings. Likewise, the denial in the return statement should be specific. A mere denial like the plaint amendments in paragraph 3 or 4 are false may not henceforth suffice. What the present amendment requires is that the defendant shall state which of the allegations in the particulars of the plaint he denies, which allegation he is unable to admit or deny, but which he requires the plaintiff to prove, and which allegation he admits. Whenever a specific denial of an allegation in the plaint is made, the defendant has to state the reasons for doing so, and if he intends to put forward a different version of events, he must state his own version. There is a new proviso inserted to Order 8 Rule 5 to the effect that non-denial to every allegation of fact in the plaint shall be taken to be admitted. The amendments with regard to discovery, disclosure, and inspection of documents prescribe completion of pleadings in a time-bound manner. Likewise, if interest is claimed in the suit, specific details as to how such a claim is made requires to be spelled out in the pleadings. There are two other significant amendments brought in through this legislation. A provision has been made for the court to decide a claim pertaining to any commercial dispute without recording oral evidence. Such a summary judgment could be pronounced after service of summons and before framing of the issues on the grounds that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of defending the claim, or there is no other compelling reasons for not passing a summary judgment. And lastly, and more notably, is the introduction of case management hearing under Order 15A, which I had referred earlier. As per this amendment, the court shall hold case management hearing within 4 weeks from the date of filing of the affidavit of admission or denial by framing issues and setting time limits for conduct of trial and oral arguments. This requires to be held within 6 months from the date of the first case management hearing. Various powers have been conferred on the courts to effectively manage the case management hearings and facilitate a speedy disposal. For instance, non-appearance of the advocate will not be a ground for adjourning the case management hearing. And when a party fails to comply with the orders of the court passed in the case management hearing, severe consequences have been provided for, like foreclosure of certain rights of the non-compliant parties during the trial, or dismissal of the plaint, or allowing the suit or imposing costs, and so on and so forth. Ultimately, the basic idea for introduction of case management hearing is to facilitate speedy disposal of the suit. Thus, if you carefully look into all these amendments, the core intention is for speedy disposal of the suit. Speaking of speedy disposal, I would like to touch upon an incidental issue, but would think it fit to leave it unanswered. The explanation to the definition of a commercial dispute under Section 2 of the Commercial Codes Act also includes such disputes where the state is one of the contracting parties. We all know Article 12 of the Constitution of India defines state to include the central and state governments. Thus, whenever a dispute of this nature arises, and even though the plaintiff may qualify to maintain a writ petition under Article 226 of the Constitution of India, a commercial suit against the state would be the appropriate remedy, since that also is the intention of the Commercial Codes Act. But commonly, in a dispute against the state, the reason why a litigant chooses to opt for a jurisdiction and not the civil jurisdiction could be because of the non-cumbersome procedures and the possibility of a speedy disposal. In these circumstances, if any of the viewers raise a question that as to whether a writ petition would be barred when a commercial dispute against the state has been made out, I would only mention the settled proposition of law that a remedy guaranteed under the Constitution of India cannot be taken away by a statute, and all further doubts in this regard requires to be answered on the judicial side. To sum up, the reasons for bringing up this important legislation is to establish commercial courts at the district level and commercial division in the High Court, and a commercial appellate division for dealing with decisions taken by the commercial courts and the commercial division. The Act further endeavors to reduce or curtail unwanted delays in the suit proceedings, for which purpose certain revolutionary changes have been made to the Civil Procedure Code. These are the ultimate reasons of this legislation. Having dealt with the reason for bringing in this legislation, it is imperative that each and every individual who deals with this act should know the object behind the enactment. Why suits which are commercial in nature alone should be put on the fast track. Before I deal with this, with the object behind this, let us remind ourselves of some ugly truth in our system. It is a bit of disappointment and yet a matter of concern to realize that a considerable number of citizens of this country dread to approach the courts to redress their grievances, fearing the delay in disposal of the case. It is not as if the stakeholders have not attempted to address this menace. There have been consistent attempts through researches, deliberations to address this issue, which is evidenced in several reports of the law commissions. The numerous and consistent amendments to several legislations, improvement to the infrastructures, establishment of model courts, computerization. These are some of the attempts made to curtail this problem. This problem did not restrict itself in creating an inhibition among the potential litigants of this country, but also extended considerably so as to affect the economic growth of our country. Studies reveal that there is an impression among foreign investors and foreign companies that India is a difficult place to do business in view of the existing civil justice system. Therefore, the importance of an efficacious judicial system was found to be the only solution for development of trade and commerce. It further reveals that there are remarkable improvements in the financial markets in countries where the legal system was effective, and many of these nations had adopted commercial courts as a means to ensure speedy delivery of justice in commercial cases. We must be conscious of the fact that a mere change in the substantive law alone may not be the solution to reduce the delay in disposals, but there has to be a substantive change in the procedural law to achieve this object. In this background, the concept of commercial courts came to be crystallized through the present enactment. The Law Commission of India, in its 253rd report, have given three reasons for the need of commercial courts in India. First is economic growth. Second, improving the international image of the Indian justice delivery system. Third, improving legal culture. The first need, economic growth, is to the need for it was felt that the importance of an efficient dispute resolution mechanism for quick enforcement of contracts, easy recovery of monetary claims, and awards of just compensation for damages suffered are absolutely critical to encourage investment and economic activity, which necessarily involves the taking of financial and enforcement risks, and therefore such a mechanism would be essential to the economic development of any nation. While conducting a study on the transition countries of Eastern and Southeastern Europe, it was found that changes to the substantive law was of little avail, while the financial markets flourished only in countries which had an effective legal system. Thus, it was realized that if the justice delivery system is made effective, it would in turn attract foreign investments and thereby contribute to the economic growth of our country. The second reason cited is to improve the international image of the Indian justice delivery system. In the year 2014, the World Bank had surveyed 189 countries under the ease or difficulty of enforcing contracts in a given nation. And among these 189 countries, India was ranked 186. The category was contract enforcement. It was also found that there was no major reforms in contract enforcement. Obviously, this image may not attract foreign investments, and for this reason also, the justice delivery system was sought to be improved. While the first two reasons of economic growth and improving the international image of the Indian justice delivery system are important, the third need expressed by the Law Commission raises a lot of concern to the legal fraternity, that is, the need for improving legal culture. We, the members of the legal fraternity, are part of a system which is held accountable now of being slow in justice delivery system. Any number of changes brought to the substantive laws could not influence the strength or could not influence the sluggish progress of the cases, since there was no revolutionary change to the procedural law. There was always a way to manipulate the procedures. All along, we have been taught and made to believe that a casual adjournment in a civil suit proceedings for no satisfactory reason is quite normal. We have been cultured to say that a civil suit that takes about 3 or 4 years' time for its disposal is not an inordinate delay. We have all along been cultured to think that in a civil proceedings, when the written statement is filed within 30 days from the summons, thereafter documents are inspected within 30 days, and affidavit of admission or denial are filed within 15 days therefrom. And consequently, when the trial and arguments completes within 6 months, and when it is realized that the entire proceedings ends within a year, it is abnormal. The Commercial Courts Act is a revolutionary piece of legislation. It has plugged in the major holes which contribute to the delay in the suit proceedings. And while doing so, it has also taken a whip in its hand. The amendments to the code have taken away the discretion of the courts to grant unnecessary and unwanted adjournments, and even while granting the limited and permissible time, such lenience come coupled with imposition of costs. Vexatious claims henceforth are mandated to be dealt harshly, thereby paving way to reduction of frivolous claims. The procedure in the commercial suit, being considerably new, requires even the most experienced advocates to reappraise themselves of the procedures. Interestingly, some of the amendments to the Code of Civil Procedure mandates the manner and form of drafting of pleadings and affidavits, which are very rarely found in commercial suits instituted prior to the amendment. Looks like that it may not now be possible for a conversion of pleadings into affidavits through a cut and paste technology. It is said that old practices seldom change, but now there is no option. The culture of old practices requires to be changed. There is a provision under this Act for a training and continuous education for judges of the commercial courts. From the very inception, the National Judicial Academy as well as the state judicial academies have already ventured to impart the required training to the judges. The bar councils and the bar associations should also follow suit if not already done. This alone could be the best practice to educate ourselves of the new procedures. The last doubt that could be raised in this context is why suits of commercial nature alone should be put on a fast track. The report answers this question. The commercial courts have been set up as model courts, establishing new practices and norms of practice in commercial litigation that can, over a period of time, be scaled up and extended to all civil litigations in the country. The high pecuniary value is also suggested for relaxation, and the amendments to the Code of Civil Procedure are contemplated for extension for all disputes in future. The commercial courts have been brought in as a pilot project to reform civil litigation across the country and thereby tackle the issues of pendency and arrears. Thus, the object is to largely reform the entire Code of Civil Procedure and extend it to all forms of civil litigation and thus bring about speedy and efficacious disposal of civil suits. I do not find any reason whatsoever as to how any party could be prejudiced at all on a speedy disposal of a case. All this depends on the success of the Act, which in turn depends on the contribution from the bar in adhering to the new procedures and the contribution of the bench in strictly enforcing the amended procedures in the code. In my view, this is the first and only kind of legislation which reasonably seems to be infallible in tackling the issue of pendency and delay. The object of the Act is legitimate and for the betterment of a country as a whole and the justice delivery system in particular. Before I conclude this lecture, I would like to share a small thought of mine. I am given to understand that the present Act has been proposed for further amendments by liberalizing some of its salient features, including reduction of the specified value from 1 crore to 3 lakhs and expanding the hierarchy of the commercial courts. I am of the view that such changes within such a short time after the establishment of the commercial courts could be considered after the present Act is put to its full use and after a strong foundation is laid. With this few words, I once again thank the MBA Academy for giving me this platform. Thank you.